Good evening, my dear friends. In today's session, we will discuss about the features of bankers' general lien because bankers are entitled to exercise general lien under the Indian Contract Act as we have discussed in our earlier lessons. So, we are going to discuss about the bankers' general liens features. The first feature is that the bankers have a right of general lien as an implied pledge. This is the most important aspect. The banker has the privilege of a pledge in case of applying a general lien, and the banker can dispose of the securities after giving proper notice to the customer under section 176 of the Indian Contract Act. Then this particular right of lien is viewed as more than a general lien, as the whole concept resembles a pledge, and it is usually called as implied pledge. In 19th century, the House of Lords in Barnett, Brandio versus Barnett, has decided a matter in this regard. It was reported in 1846 12 CL&F 787 House of Lords. The House of Lords held in this case that the bankers most undoubtedly have a general lien on all securities deposited with them as bankers by a customer, unless there is an express contract or situation which shows that there is an implied contract inconsistent thereon. Otherwise, it is an implied pledge. Then, friends, another case, the Apex English Court, it's a Queen's Bench decision, Burdick versus Sewell. Burdick versus Sewell, reported in 1884 13, Queen's Bench decision 159. The English court here held that the right of lien of a banker is regarded as an implied pledge for the reason that in case of negotiable instruments like coupons, bearer bonds, share warrants, which are kept into the custody of the banker as securities, they become liable to the lien, and the characteristics of a pledge enable the banker to sell the securities on default. If a time is fixed for the repayment of the advance, or where there is no time fixed, after request for repayment and reasonable notice of intention to sell were made, and thereby apply the proceeds in liquidation of the amount due to the bank. The right of sale extends to all properties and securities belonging to the customer in the hands of the banker, except the title deeds of immobile property, which obviously cannot be sold, as in that case the banker has only right to retain the deeds, otherwise he has to go to court and get an order. So these English court decisions were followed by the Indian courts, and then now this is a universal principle that the right of lien of a banker has become an implied pledge. Now, friends, we'll come to the second point. That the second point is that the right of lien can be exercised against any movables. This right can be exercised by the bankers on goods or other securities standing in the name of the debtor only. Then the third right is that the right of lien exercisable by the banker. These are the features we are discussing. The third feature, the right of lien is exercisable by the banker as provided under the Indian Contract Act. That is the reason why I have elaborately covered the provisions of IC, that is the Indian Contract Act 1872. Now, of course, For this particular features, there are certain exceptions. What are they? This right cannot be exercised under certain circumstances. What are they? Number one, the documents deposited for a particular purpose cannot be used for all as a general balance of account. Like in documents sent by a customer with specific instructions utilized for a particular purpose, like the bill of exchange, such kind of things, the banker cannot deviate from the instructions. Then the second one is safe deposit, custody deposits, like lockers, is safety custody deposits like valuable securities, documents, gold, silver. The banker's status is that of a bailee and also a trustee also, with the responsibility to ensure that they are safe from burglary, fire, and other exigencies. So, a contract inconsistent with the right of lien exists here, and in case of safe deposit lockers, the banker cannot exercise the right of lien. Then, friends, the third exception, the right of general lien becoming a particular lien, where under certain circumstances the general lien will become a particular lien, then the right of general lien would cease to exist. The fourth one, the securities which are held in trust, where the securities are deposited with the banker as a trustee, banker being the trustee, the banker then cannot exercise his rights. Then the fifth one is the securities negligently left with the banker. In that event, the banker cannot appropriate, he cannot lay his hands on that. Then the sixth one is the exception, the conflict with the right of set off. The money deposited in the bank in the accounts of the customer and also the credit balance of the customer don't come under the category of goods and securities. Under such circumstances, banker can exercise a right of set off but not a right of lien. Then the seventh exception is contingent debt, where the banker has a contingent debt, that is, no amount would be due on the date when the banker wants to exercise lien. The right of general lien cannot be exercised. Then the eighth exception, general lien is only to the extent of liability of the customer. The Madras High Court has given a decision in this regard, City Union Bank Limited versus Thangarajan, reported in 2003-46 SCL 237 Madras. The Madras High Court held that the bank gets a general lien in respect of all securities of the customer, including negotiable instruments and the FDRs, but only to the extent to which the customer is liable. If the bank fails to return the balance and the customer suffers a loss, then the bank is liable to pay damages. In order to invoke a lien by the bank, there should be, in fact, a mutuality between the bank and the customer, then retaining the customer's properties beyond his liability is in fact done without any authorization, and then it would attract liability to the banker to pay damages to the customer. So friends, with this we conclude our discussion on the features of this particular banker's general lien and the exceptions thereon. And then this also could be a 25 marks question. I have covered the basic skeleton. You will have to fill it up further by further study thereon. So take care and then study further. Tanan, Varshni, and supplement your study with that. We will take up in the next session the set-off of customers and the banker's claims. So fine then, we will meet again then. Thank you, my dear friends. Goodbye, good night.